I like to think the wheels of progress, they keep progressing, even if there are
Yeah.
setbacks. I hope that is the case. I guess, before we conclude, to go back to the immigration real quick, we got a little time for terrorism case, the Hincapi Zapata v. U.S. Attorney General case out of the 11th on October 13th. I think it's a material support of terrorism case, and the case that they always are really interesting to me because
Right.
this provision of the INA, it is so expansive, and it seems that DHS is really waking up to it over the last couple of years of just how expansive it is. I mean, and with the two board decisions, one that said there is no de minimis exception, and the other saying there is no duress exception to
Could
the
you
material
explain
support
this
of.
issue for those who aren't familiar, how expansive this idea of support is? Could you explain more what it means?
Absolutely. I mean, the material support of terrorism bar, it's under 212A3BI, whatever, a bunch of stuff under 212. You look at the act. But if you have materially supported, and there's three tiers. There's tier one, tier two, and tier three. Now I can't remember what tier two is, but tier one is a designated terrorist group by the Department of State. Tier three, as I recall, are just entities that are found to have committed acts of terror, even though they're not officially designated as terrorist organizations. And if you have materially supported those entities, you are barred from all immigration benefits. And this is, I mean, everything. It's do not pass go, do not collect $200. There is no exception written into the statute except at DHS's sole discretion may it waive this inadmissibility provision. And the most of the circuit courts now and the BIA are interpreting that to mean because DHS has this discretion to waive it, that must mean that immigration judges have none, that there are no exceptions. And all you can do is go to DHS. But as this 11th Circuit case makes clear, you can't even go to DHS until the BIA has ruled. So you have to have a final order of removal before you can go to DHS to ask them to waive the ground,
Wow.
and I've never heard of anyone succeeding in. I don't even know what the process is.
Yeah.
I don't know if anyone knows what the process is to get them to do that. And what incentive does USCIS, DHS have to waive material support of terrorism? And terrorism's bad. I certainly don't condone it. But you look at the facts of something like Hincapi Zapata and what it means. I mean, many years ago, the US government designated the FARC in Colombia as a tier one terrorist organization. All right, fine. I mean, I'm certainly not a supporter of the FARC, but also I don't think that the FARC is the same as Al Qaeda.
Yeah.
And when you think terrorism, I'm not sure you're thinking FARC right then and there. Maybe we're getting a bit overbroad. The Trump administration just labeled an arm of Iran's armed services
Yeah.
as a terrorist organization. Again,
Definitely a lot.
not sure that's what we're thinking about when we're talking to. It might be bad. I don't know about that's what terrorism is supposed to be. But because the Board of Immigration Appeals, because of that carve out with DHS, the board has held that there is no duress exception. And in that case, it's a matter of ACM. And in matter of ACM, I believe Miss ACM was forced to watch her husband be murdered by guerrillas in El Salvador. And then he dug his own grave, and then they shot him in the grave. And these guerrillas were in her house, and she cooked him breakfast the next day because they forced themselves in. They said, "Cook us breakfast,"
Yeah.
and so she supported them under clear duress. But because the board said there is no exception, so Miss ACM, who is a legitimate asylum seeker, is barred under the material support of terrorism bar. To me, that's an absurd result. And it's kind of similar with the Hincapi Zapata case. This guy was extorted by the FARC in Colombia, and he paid them $100 at threat of death. And when they said that's not, and then when they kept extorting him, he fled. And I don't think he applied for asylum, but he could have, right?
Yeah.
Based on extortion demands. And because he was extorted out of $100 of the FARC, and that means he did the material support of terrorism that barred him in this case from adjusting status. To me, that can't be what Congress meant with the material support of terrorism bar. And it's because these circuits and the board are finding there is no duress exception, there is no de minimis exception, that just cooking breakfast is so minuscule that it's not really a support. None of the exceptions.
How does federal judges say this is crazy? I mean, I don't know what the state, what kind of standing or power they have or that, but it just that doesn't make any sense. When that case came with that woman just cooking breakfast for them, and they said tough luck, I'm like, what? Like, what
That
American would agree with that? Like, I don't
Yeah,
know.
that was the board, but I mean, look, it comes back to statutory interpretation that you and I were both cheering when we were talking about the
Yeah,
TPS case, and now we're saying it's
true.
terrible. But
That's
it
awful.
to
Yeah.
me, it comes back to Congress. Write a better statute. Somebody's got to be in that room and say, "Hey, guys, like this might do the matter the Miss ACMs of the world." Maybe they did think about that, and maybe it was some sort of deal made in Congress. I hope not,
That's the
but
thing, like when we think about comprehensive reform, there's things like this that got to change. There's TPS that got to change. There's L1 situations that I want change. It's just so many that eventually, when you what is that saying, the camel trading or something like that, when you're trading whatever the this and that, so many of these are going to get lost, and we're still going to be have problems with this. So even comprehensive reform is difficult. I mean, this one on its own should just, there should be some sort of congressperson pushing it, but there's no money in it. There's no political clout to try to argue this.
And it's kind of political suicide to be the guy who's fighting for terrorists. But just one more nerdy thing that I did say on the podcast when I reviewed it 2 weeks ago. It's there is the shining light in it. The material support of terrorism bar. It specifies like 10 things, including funds. So the $100 are funds. So that cuts it.
Hmm.
And those funds don't have a de minimis exception because they're articulated in the statute. But as I read this 11th Circuit case, if it's not specifically articulated in the statute, such as what Miss ACM did with just cooking breakfast, then there has to be a de minimis exception for various statutory analysis words. So the 11th Circuit might not have meant to do it, but with this case, they might have partially overturned, or not overturned, but not followed matter of ACM as to acts that are not specifically listed in the statute. So, I mean, a small victory out of a pretty rough case, but
Yeah,
I think it's something that worth noting.
definitely. So I mean, there's a lot more interesting cases that are popping up, but we could keep talking about this forever.